Hello students, this is Dr. Deepa Dubey, Associate Professor, Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. The module on which I will speak today is Rape Laws. The learning outcomes of this module are to make the learners understand the law relating to the offence of rape in India. Next, to make the learners understand the developments in the law through legislative amendments and judicial pronouncements. And third, to make the students acquainted with the key issues arising in rape cases. Rape is probably one of the most discussed offences in recent times. Following the horrific incident of Nirbhaya in the capital city of Delhi in December 2012, the law of rape became the subject of discussion and deliberation at all quarters. The Justice Verma Committee was appointed shortly thereafter to look into the laws and make appropriate recommendations. The Criminal Law Amendment Act 2013 was enacted thereafter, introducing pragmatic and long-awaited changes in the substantive and procedural laws. The offence of rape is listed in Chapter 16 of the Indian Penal Code 1860 under the heading Offences Affecting Human Body. It is an offence which has been categorized thereunder as a sexual offence. Rape is probably one of the most gruesome violations against the human body. It is an act of violence which subjects the victim to physical and emotional humiliation, besides pain, fear, and serious injury. As stated by the Supreme Court in Pushpanjali Sahu's case, sexual violence is not only an unlawful invasion of the right of privacy and sanctity of a woman, but also a serious blow to her honor. It leaves a traumatic and humiliating impression on her conscience, offending her self-esteem and dignity. Rape is not only a crime against the person of a woman, but a crime against the entire society. It indelibly leaves a scar on the most cherished possession of a woman, her dignity, honor, reputation, and not the least her chastity. It destroys the entire psyche of a woman and pushes her into a deep emotional crisis. It is a crime against basic human rights and is also violative of the victim's most cherished of fundamental rights, namely the right to life contained in Article 21 of the Constitution. So, how would one define rape? The word rape has been derived from the term rapio, which means to seize. Rape is therefore forcible seizure or the ravishment of a woman without her consent by force, fear, or fraud. It involves coercive, non-consensual sexual intercourse with a woman. The offence of rape as defined in section 375 involves a coercive, non-consensual interference or manipulation with the body of a woman by a man in a set of specified circumstances. Such interference has not been limited to penovaginal intercourse, but has been widened to include insertion of any object or part of the body into the vagina, urethra, or anus of a woman, or manipulation of any part of the body of a woman to cause such penetration, or the application of the mouth to the private parts of a woman, or make her do so with him or any other person. Thus, the offence of rape is no longer limited to sexual intercourse, but includes all other forms of vaginal, anal, or oral sex which has the tendency to violate the woman. This widening has been the result of the Criminal Law Amendment Act 2013, which has been passed in the backdrop of the Nirbhaya episode. Prior to the amendment, the offence of rape included the sexual intercourse between a man and a woman. Sexual intercourse means heterosexual intercourse involving penetration of the vagina by the male penis. The offence was thus limited to the penetration of the male organ into that of the female. The Delhi High Court in 1998 had opined that the definition of rape in section 375 was entirely based on common law understanding, wherein penetration meant the act of inserting the penis into the female organs of generation, and sexual intercourse confined itself to natural intercourse. In 2004, Sakshi, a voluntary organization, urged the Supreme Court to redefine the word sexual intercourse to include all other forms of penetration such as penile vaginal, penile anal, finger vaginal, finger anal, object vaginal, etc. However, the apex court declined to alter the definition through judicial interpretation. However, post the 2013 amendment, the term sexual intercourse has been done away with, and all forms of penetration and manipulation with the body of a woman has been included within the meaning of the offence of rape. The offence is said to have been committed when it is committed under any of the specified circumstances laid down in the section. These circumstances include 1. Against her will, 2. Without her consent, 3. With her consent when her consent has been obtained by putting her or any other person in whom she is interested in fear of death or hurt. Next, with her consent when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. Next, with her consent when at the time of giving such consent by reason of unsoundness of mind or intoxication or the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that to which she gives consent. Next, with or without consent when she is under 18 years of age. And last, when she is unable to communicate consent. The first two clauses, which deal respectively with intercourse with a woman against her will and without her consent, contemplate a conscious woman capable of exercising her will or giving or withholding her consent for the sexual act. The next two clauses, which deal respectively with the consent of the woman obtained by putting her in fear of death or hurt or making her to believe that she is his wife, contemplate consent of a woman who is conscious but either afraid or under a misconception. The next three clauses deal with the consensual sexual intercourse with the woman who is due to either insanity or immaturity or disability, incapable of exercising her will or giving consent. Against her will. This is the first clause of section 375 IPC, which refers to a fully conscious normal person, one who is in full possession of her senses and reason and is capable of exercising her own volition. Every act done against the will is done without consent, but act done without consent is not necessarily against the will of the person. Gore says that consent and will are functions of volition, where will refers to that faculty or power of the mind by which we determine either to do or not to do something. It implies consciousness, cognition, and mental determination. Without her consent. Consent is the most essential ingredient to the offence of rape. Explanation 2 to section 375 provides the meaning of the term consent. In the context of rape, it provides that consent means an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. The proviso further clarifies that the woman who does not physically resist to the act of penetration shall not, by reason only of that fact, be regarded as consenting to the sexual activity. Prior to the Criminal Law Amendment Act of 2013, no meaning of the term consent was provided in this section. Reference may be made here to section 90 in the code. The term had been interpreted by the courts therefore in diversified manner. Way back in 1958, the Punjab High Court had clearly stated that a woman is said to consent only when she freely agrees to submit herself while in free and unconstrained possession of her physical and moral power to act in a manner she wanted. Consent implies the exercise of a free and untrammeled right to forbid or withhold what is being consented to. It is a voluntary and conscious acceptance of what is proposed to be done by another and concurred in by the former. That was the case of Rao Harnarayan versus State 1958. Consent therefore means active consent in the mind of the person to permit the doing of the act and the knowledge of what is to be done. It involves voluntary participation. In this regard, section 114A of the Indian Evidence Act introduced in 1983 provides a presumption as to absence of consent in certain prosecutions for rape. According to this section, where sexual intercourse by the accused is proved and the question is whether it was without the consent of the woman, and she states in her evidence before the court that she had not given consent, the court has to presume that consent was not given by her. Consent under fear of death or hurt. Consent obtained under fear of death or hurt is no consent for the purposes of section 375 IPC. It has been extended wherein under fear of death or hurt to any person other than the victim also constitutes the offence of rape. One aspect which may however be looked into is that the word hurt has been used here instead of the word injury. The latter is a wide term including harm illegally caused to body, mind, reputation or property. Hurt is considerably narrower, indicating harm illegally caused to body only, that is in a physical sense. The next clause speaks about consent under misconception of fact, means a mistaken belief or false belief. Consent given by a woman to a man under a mistaken belief that he was her husband is no consent at all if the man knew that he was not her husband. In the present world, cases of date rapes or acquaintance rapes are quite common. In cases where a man impersonates another and has sexual intercourse with an unmarried woman, the latter would not be allowed to allege that the man she had intercourse with was not her partner or one with whom she was dating with. A question which arises in this context is whether an intercourse on promise of marriage could vitiate consent as enumerated in section 90 of the Indian Penal Code and thereby amount to the offence of rape. The Calcutta High Court had opined that if a full-grown girl consents to the act of sexual intercourse on a promise of marriage and continues to indulge in such activity until she becomes pregnant, it is an act of promiscuity on the part and not an act induced by misconception of fact in Jayanti Rani Panda v. State of West Bengal 1984. However, in later day cases, the courts have opined that consent for sexual intercourse obtained by a false promise to marry is not a true consent. A deliberate representation by the accused with a view to eliciting the assent of the victim without having any intention or inclination to marry her vitiates the consent. But where the accused's promise is not false and has not been made with the sole intention to seduce the prosecutrix to indulge in such acts, then the act would not amount to the offence of rape. An accused can be convicted for rape only if the court reaches a conclusion that the intention of the accused was malafide and that he had clandestine motives. There are several cases in which the same has been held. Coming to the next, consent under insanity or intoxication, where the mental faculties of the woman are clouded and she has lost her ability to judge the acts and consequences arising therefrom due to drugs or other substance, the accused would be guilty for an offence under this clause. Consent by a minor. Clause 6th of section 375 IPC lay down that where the victim is a girl aged below 18 years, previously 16 years, her consent becomes immaterial to the offence of rape. In other words, she may consent to the act of intercourse, but the very fact that she is below the stipulated age, the law regards her of being incapable of discriminating between right and wrong, and the accused would be guilty of the offence. Lastly, inability to communicate consent. This provision has been included by the latest amendment to take account of all such cases where a woman, because of physical or mental conditionalities, may be unable to communicate consent. Thus, where an accused has intercourse with an unconscious girl, the act would constitute rape since her unconsciousness prevented her from communicating her consent or otherwise to the act in question. Similarly, in T. Kanolkar v. State of Goa, the Honorable High Court had held that a mentally challenged girl can never give her valid consent since she cannot understand the nature and consequences of the act to which she consents. Exceptions. There are two exceptions to the definition. The first exception says that a medical procedure or intervention shall not constitute rape. Next, marital rape exemption, that is the second exception to section 375, which states that non-consensual sexual intercourse by a man with his own wife, the wife not being under 15 years of age, is not rape. It thus keeps outside the ambit of rape a coercive and non-consensual sexual intercourse by a husband with his wife above 15 years of age, and thereby allows a husband to exercise with impunity his marital right of non-consensual or undesired intercourse with his wife. The legal justification is based on a declaration by Sir Matthew Hale made some more than 300 years ago that the husband cannot be guilty of rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract, the wife has given up herself in this kind unto her husband, which she cannot retract. Scholars maintain that this exemption aims at the preservation of family institution by ruling out the possibility of fake, fabricated and motivated complaints of rape by a wife. However, in present times, it is more representative of patriarchy and patriarchal values rather than protection of the family. The term wife here refers to a legally wedded wife and excludes from its ambit a wife under a decree of judicial separation. In case where a forced sexual intercourse involves a man and wife who are judicially separated, the husband is liable to be punished for a term of 2 years, which may extend to 7 years, and fine under section 376B IPC. Key issues in rape cases. The offence of rape is cognizable, non-bailable and triable by the Court of Sessions as laid down by the Code of Criminal Procedure 1973. While the trial for the offence follows the same procedure as in case of any other offence prescribed under the penal code, research shows that such trials somewhat attain a peculiarity. In most cases, the trial revolves around the complicity of the woman in the offence in question rather than the culpability of the accused. The testimony of the woman, the injuries she sustained, her character are put to microscopic scrutiny in the courts of law, and the slightest lapse on the part of the woman makes her a consenting party to the offence in question. In this context, we may examine some of the core issues which have been established by the courts over the years to ascertain the exact position with regard to trials in rape cases. Delay in FIR. Section 154(1) of the Code of Criminal Procedure provides that every information given to a police officer of the commission of a cognizable offence shall be recorded. In case where the offence relates to one against women, including outraging of modesty or rape, etc., such information shall be recorded by a woman police officer and preferably at the residence of the woman, and the same shall be videographed. The Supreme Court has held that the provision of section 154 of the code is mandatory and the concerned officer is duty bound to register the case on the basis of information disclosing a cognizable offence. In cases of rape, however, there has been delays due to the refusal of the police to register the FIR. Sometimes delays have been due to the victim's own hesitation to file a complaint and thereby make the public the fact of rape. The Supreme Court has held that delay in filing FIR by the prosecutrix or parents in all circumstances is not of significance, but it must be well explained and the explanation must be tenable. Testimony of the victim and the necessity of corroboration. A woman who has been raped is not an accomplice. If she is ravished, she is the victim of an outrage. Corroboration therefore is not a sine qua non before there can be a conviction for the offence. In Gurmeet Singh's case, the apex court held the testimony of the victim is vital, and unless there are compelling circumstances, the courts should not hesitate to act on the testimony of the victim and convict the accused. To insist on corroboration is to equate a woman with an accomplice to a crime and thereby insult womanhood. Absence of injuries and consent. The Criminal Law Amendment Act 2013, by virtue of explanation 2 to section 375, has clarified that a woman who does not physically resist to the act shall not, by the reason only of that fact, be regarded as consenting to the sexual activity. However, in several cases in the past, it had been seen that absence of injuries had been interpreted as consent, but the apex court has held that the absence of the injury may or may not indicate absence of physical violence, and absence of physical violence by itself does not mean that sexual intercourse has not been committed forcibly. Coming to medical examination of rape victims, it is a very crucial aspect in a rape case. Medical examination of the victims help the court to ascertain the fact of sexual assault on the victim. It establishes whether there are lacerations, bruises, injuries on the private parts of the woman and accused, as well as whether there is presence of semen in the private parts indicative of a sexual activity. Section 164A of the Code of Criminal Procedure provides for a medical examination of the victim of rape within 24 hours of the incident. Such examination must note the particulars of the woman along with the marks of injury on the person of the woman, her mental condition and other relevant material in reasonable details. The section also provides for DNA examination of the victim. In a recent judgment of the Supreme Court in 2013, the court verified that the two-finger test violates the right of rape survivors to privacy, physical and mental integrity and dignity. Thus, this test, even if the report is affirmative, cannot ipso facto give rise to presumption of consent. Medical procedures should not be carried out in a manner that constitutes cruel, inhuman or degrading treatment. Proper measures should be taken to ensure their safety, and there should not be any arbitrariness or unlawful interference with the privacy of a woman. In many cases, rape trials turn out to be a game of chastity, fidelity and gender stereotypes. Emphasis is placed on the womanly behavior of a woman, her unfaithfulness towards her husband, her loss of virginity, etc., to determine the issue of rape. Previously, Section 155(4) of the Indian Evidence Act sanctioned the admission of character evidence in rape prosecutions. The same, however, stands deleted in present times. Section 146, dealing with questions lawful in cross-examination, mentions that in a prosecution for rape, where the question of consent is an issue, it shall not be permissible to adduce evidence or to put questions as to the general immoral character or previous sexual experience of the victim. The Supreme Court has criticized the approach of stigmatizing the victim and engaging in her character assassination, saying even a woman of easy virtue is entitled to privacy and no one can invade her privacy as and when he likes. In camera proceedings and anonymity of victims, Section 327(2) Code of Criminal Procedure provides that trials of rape must be held in camera. Furthermore, when trials are held in camera, it would not be lawful for any person to print or publish any matter in relation to the proceedings of the case except with the previous permission of the court as envisaged in Section 327 subsection 3 of the code. This provision would further save the victim from unnecessary embarrassments. Punishments for the offence. Section 376(1) lays down the punishment for the offence of rape. It prescribes rigorous imprisonment for a period of 7 years, which may extend to imprisonment for life as well as fine in case an accused is convicted of an offence of rape. Subsection 2 of Section 376 thereafter enumerates certain aggravated forms of the offence which attracts higher penalty under the law. These aggravated circumstances include the following: a rape committed by a police officer in custody, rape by a public servant in his custody, rape committed by a member of the armed forces, a rape committed on the inmates of any jail, remand home, etc., rape of a woman in a hospital by the management or staff of the hospital. Next, a rape of a woman by a person in position of trust or authority towards such woman, including the relative, guardian or teacher. Rape of a woman committed during communal or sectarian violence. Rape of a pregnant woman. Rape of a woman under 16 years of age. Rape of a woman incapable of giving consent. Rape of a woman by a person in position of control or dominance over such woman. Rape of a woman suffering from mental or physical disability. Rape which causes grievous bodily harm or maims or disfigures or endangers the life of a woman. Rape committed repeatedly on the same woman in all of the above cases, the offence shall be punished with rigorous imprisonment for a term not less than 10 years, but which may extend to imprisonment for life. It has been further explained that the latter shall mean imprisonment for the remainder of the person's natural life. Section 376A D E lays down further instances wherein the offence of rape attracts a higher penalty under the law. The first two entails situations where the offence proves dangerous or life threatening to the victim and her well-being, while the last one includes such offenders who are a menace to the society and need to be secluded by way of custodial sentence from the society. In all such cases, the punishment shall not be less than 20 years, but which may extend to life and even death. Lastly, with regard to punishment, the Criminal Law Amendment Act 2013 has deleted the provisos to section 376(1) and 376(2) which permitted the courts to reduce the sentence for adequate and special reasons to be mentioned in the judgment. This is because a glance through the judicial decisions reveal a lenient attitude of the judiciary towards the offenders. In most situations, the reduction of sentence was not based on sound principles, neither it commensurated the harm perpetrated, nor it took into account the plight of the victim. Banerjee J. in Jai Kumar vs. State of Madhya Pradesh acknowledged that while it is true that a sentence disproportionately severe ought not to be passed, but that does not mean even clothe the law codes with an option to award a sentence which would be manifestly inadequate, having due regard to the nature of the offence, since an inadequate sentence would fail to produce a deterrent effect on the society at large. Punishments are awarded not because of the fact that it has to be an eye for an eye or a tooth for tooth, rather having its due impact on the society. While undue harshness is not required, inadequate punishments may lead to sufferance of the community at large. Thank you.